I'm with Holland and Hart. I see that it's noon. I also see that we have some folks who are still signing on. So I just want to give it one more minute to allow a few more people to sign on, and then we will go ahead and get started. All right, why don't we go ahead and get started. Thank you everyone for participating in our continuing healthcare webinar series, and today's webinar is on 2021 employment laws and trends impacting healthcare employers. My name, as I mentioned before, is Mark Waletsky. I am with the Labor and Employment Group at Holland and Hart. I am based in our Boulder, Colorado office, and I am happy to have my colleague Lori Rogers with me today. Lori, do you want to introduce yourself quickly?
Yes, thanks, Mark. Like Mark, I'm also an employment attorney with Holland and Hart in the Labor and Employment, and I am based out of Cheyenne.
Great, thanks, Lori. Just so everyone knows, this webinar is being recorded. The materials and the recording will be posted to our health law blog on the website after the webinar so that folks will have access to it. If you have questions, and we encourage questions during this webinar, please feel free to use the Q&A function. We will absolutely do our best to respond to questions as they come in. Please don't feel like you have to hold your questions to the end, but if you want to, that's fine. We may not be able to get to every single question. We will do our best, though, to do so. So with that, let's go ahead and jump in. I'm going to skip the disclaimer slide. Okay, so here's what we plan to talk about today in terms of employment laws and trends impacting the healthcare industry. First, there's some new federal wage and hour guidance that we want you to be aware of, and just some general reminders on wage and hour law as well, because as Lori and I have seen, this area just continues to be fraught with risk, both for healthcare entities and for others as well. It's just a hotbed for litigation. So we'll be talking a little bit about that. We'll be talking a little bit about expanding state regulation for physician non-compete agreements as that continues to evolve. We also will touch on paid leave laws, especially some recent trends in legislation that we're seeing to make sure you're aware of it. Lori is going to talk about diversity, equity, and inclusion initiatives, which is a very hot topic these days. And then lastly, documenting employee performance issues, not necessarily a new trend, but something that still remains incredibly important to helping to mitigate risk of lawsuits or claims from employees or former employees. So with that, let's jump right into wage and hour, and we really focused on some what we consider to be high-risk issues. And at the top of the list, and this is especially true for healthcare entities, are meal and rest periods. The reason this is such a hot topic and such a hot area is because healthcare entities, especially hospitals or physician practices, or really anyone that is dealing in any way with a patient-facing service, often has employees who may be, number one, they're not able to schedule a set lunch period at all times, or one that will occur at a set time each day that they work. But number two, there is just a higher likelihood, frankly, for interruptions. A physician comes in, for example, and asks a nurse, "Hey, what happened with that patient so-and-so?" Or, "Hey, can we talk about this chart?" Maybe it's only going to be a minute or two, and so no one thinks much of it. But you should really be aware that those interruptions can end up turning into lawsuits, in part because state meal and rest periods are often more restrictive than federal law, and they're becoming more restrictive each year and in different states. And so let me just give you an example of Colorado. Obviously, California is another one that comes to list, but since I practice in Colorado, that's an easier one to use for me. But Colorado talks about having a uninterrupted and duty-free 30-minute meal period. And if people don't get that because it was interrupted, even if only briefly, that can lead to claims down the road, not just by one employee, but by whole classes of employees that say, I really wasn't given an uninterrupted and duty-free meal period on a regular basis. I was interrupted by someone, something, my manager needed something, someone needed something. And as a result, that was compensable time. I should have been paid for it. And in fact, that really should have been paid as overtime, because when you add it all together, if you added 30 minutes for each day that I worked, that would have put me into overtime. So these claims and these issues that arise from meal and rest period interruptions may seem minor, but let me tell you, when you have 5, 10, or as in a current case I'm handling, 200 current and former employees all saying that over a 3-year period, their meal periods were regularly interrupted, the numbers add up fast. So be aware that that's an issue. Now, having a policy in place that says, hey, you're entitled to duty-free and uninterrupted meal period is great. That's helpful. That's not going to get you all the way there, unfortunately, because if people are being interrupted, they need to know in no uncertain terms they can either add on time so that they get a full 30 minutes. That might mean completely restarting the meal period, or they can just count that meal period as compensable time. And that's where we sometimes see problems, and this flows into the second point under this topic, which is a lot of organizations have automatic deductions for meal periods, where it will just, a 30-minute period will be automatically deducted. And sometimes organizations will say, yeah, look, you can tell us if you actually performed any work and get paid. And again, that's a good policy to have. But we see sometimes employees saying, yeah, that was a policy, but my manager never allowed me to do it. And then you have a conflict and a dispute. So if employees are forced to clock in and back out, clock out for the meal period and then clock back in, which is technically what they're supposed to do under the Fair Labor Standards Act anyway, you'll have a better chance of avoiding these types of claims. You also ought to think about if people are eating at their desks. And again, or I should say, one of the things I should have noted at the outset is we're really talking here about your non-exempt overtime eligible staff. That's who we're talking about here. So if you have non-exempt overtime eligible staff who are, for example, eating at their desk or workstation, you have a much higher likelihood of a potential claim because someone will say, yeah, I was at my desk, I was checking my emails, I was doing this, I was doing that. And so I really should have been paid for that time. So just be aware that is a hot button issue in a lot of jurisdictions, not just limited to California or the coastal areas. That is happening in other jurisdictions as well. Another issue that we see, and this is not new, but it's something that we continue to see from time to time, is that non-discretionary bonuses, incentive pay, or pay differentials, for example, for working a holiday, a night shift, something like that, are not included in the overtime calculation. And that's a problem because really all compensation should be included in that overtime calculation. It is true that certain discretionary bonuses can be excluded, but I always say that our kind of understanding and just general interpretation of the word discretionary is not the same as how the federal and state agencies define that term. So if you have discretion, for example, to pay, anywhere from $0 to $10,000, you would think, well, that's discretionary. But if you told someone about this bonus in advance, for example, or you say, hey, if you work hard, you could be entitled to this, that, or the other, then it's non-discretionary because you have provided the opportunity for that bonus. So don't forget to include any non-discretionary bonuses, incentive pay, or pay differentials into the overtime calculation because that too can often lead to one of these technical violations. And by the way, for those of you who may not have had any experience with a wage and hour lawsuit, and kudos to you if you have not, but if you haven't, you should be aware. So I mentioned you could get a group of employees. This is one of those areas where we often see what's called a collective or class action, where current and former employees band together to file a claim or series of claims. So you might be dealing with a large group. And if they win, they get double damages typically. So if they win, let's say $100,000, that's going to be doubled to $200,000. There are sometimes state law penalties thrown in there as well. And then there's attorney's fees too. So that's why we wanted to highlight this issue because it really can be a dangerous area for organizations and especially healthcare entities. Lastly, one of the things that we sometimes see is a failure to pay for training time. And this can be one of those difficult things of, well, when do we have to pay for training time? And the rules under federal law give some guidance for that. And really, you have to meet these 4 criteria for training time not to be compensable. It's got to be outside of the employee's regular working hours. Of course, it has to be voluntary, not directly related to their job, and they can't perform any productive work during attendance. So if you send someone to training on a day that they would otherwise be working, even if it's an out-of-town training, that time may be compensable. Frankly, the travel time may be compensable. And again, we're talking about your hourly employees, your folks who are overtime eligible. So just be aware that when you have training, if you want to treat it as not compensable, not work time, you really have to make sure that you are fitting within the criteria under both federal and state law. And as I mentioned, state law sometimes is more restrictive than federal law. So don't forget to check the states you're in. And also, different states and sometimes cities are setting different minimum wage requirements. Now, some of you may have been following the back and forth that's going around in Congress about raising the federal minimum wage to $15 an hour. We'll have to see how that comes out. I really don't know one way or another, but I do know that some states and some cities are already making changes to their minimum wage and raising that. So that's often not an issue for the majority of your employees, but there may be a few here and there where that becomes an issue. The last issue on the wage and hour topic that we wanted to address is a trend we're seeing with vacation and paid time off. A lot of organizations have provisions where people forfeit or lose a certain amount of paid time off or vacation if they don't use it within the calendar year, or sometimes it's not paid out in full on separation. Just it might depend, but be aware that states are, and Colorado is one of them. Some states have become more restrictive. California, same way, where that is a problem. Now in Colorado, it's still a gray area because we have an agency that has said you can't forfeit any accrued vacation time, and we've had a couple court decisions saying, nope, you can. And we're waiting for the Colorado Supreme Court to rule on that. But just be aware that is definitely something that is impacting employers, including healthcare entities that are providing vacation or other paid time off. All right, Lori, you want to take over from here? I will advance the slides when you're ready.
Sounds good. Thanks, Mark. So talking about states becoming more restrictive, we have to talk about physician non-compete agreements. It's one of the most talked about employment law topics in the healthcare industry. And for some, like hospitals, private practices with physician owners, it's an important tool. That's because it protects the investment in physician practices, things like training physicians and efforts made to expand the number of patients. Physicians, on the other hand, of course, are the opposite. They concerns that overly restrictive non-competes limit their employment opportunities or their ability to start their own practices. But then outside of these negotiations for these non-competes, in state legislatures and on the national stage, there are concerns about whether these non-competes limit the availability of patient care and are in the best interest of the patients. I'm sure you guys are all aware of that. And these concerns have led to increased regulation of non-compete clauses in certain states, and I've listed 10 of them here. This is a trend to keep an eye on. I understand that in 2019 and 2020, at least 9 state legislatures considered outright prohibitions on non-compete clauses for healthcare providers or limits on their enforceability. There's no federal law governing the enforcement of non-competes. Rather, it's regulated by state law, and it differs from state to state. The good news for those of you who use them, states enforce physician non-competes that are reasonable in duration and geographic scope. Now, some states have statutes that prohibit outright any non-compete agreements in the employment context. For example, in California, it seems like we're always bringing up California for these exceptions. Non-competes are generally unenforceable except under very narrow exceptions, and physician non-competes are not one of those exceptions. Some states impose restrictions on physician non-competes. New Mexico prohibits non-competes that prevent physicians and other healthcare providers from providing clinical healthcare services, but then carves out an exception for shareholders, owners, partners, or directors of the practice. And that was just one example. Colorado is another state with specific restrictions. And I believe, Mark, you've worked with such non-competes recently, and you're going to discuss those restrictions now.
Yeah, absolutely. And before I jump into that, let me address a question that was asked on a prior slide. The question is whether clinics or hospitals offering a job shadow to an applicant, would that be compensable training? And the answer is, I'm not sure. It would depend on the nature of the job shadow. I mean, if someone is really not employed, you don't owe them anything. The question is whether during that job shadow, you essentially are forming an employment relationship before a formal offer has been issued. And so I would be concerned and cautious about that, and want to check the state in which you're operating and find out, how long is the job shadowing? What's happening during that? Is this individual literally just following someone around for a couple hours, or are they actually doing something hands-on? Hopefully not, if they haven't been hired. But that's something I would want to be careful about before concluding it's not compensable time and you haven't formed an employment relationship. With respect to Colorado physician non-competes, the statute in Colorado governing non-competes, it's similar to Delaware and maybe some other states as well, says, look, you can't prohibit a physician from practicing medicine. So in other words, you can't get injunctive relief or a court order saying that a physician cannot practice in a certain area or within a certain period of time. However, the statute does specifically allow practices or hospitals to have physician non-competes that authorize damages related to competition. They always have to be reasonable restrictions in terms of duration and geographic scope, but you can have a physician non-compete, for example, that says if physician practices medicine within a 5-mile radius of, this area or these clinics or whatever it is within a year or 18 months of leaving the practice, then the physician will be liable for damages. A lot of physician non-competes that I see have a liquidated damages provision, which just means, for those of you who haven't dealt with that, it just means, look, we're not quite sure how we're going to figure out what the damages really are if there is competition, and so we're going to agree to a set amount. It's going to be $100,000 or $200,000. The problem with those types of provisions, although they are widely used, is that they are often challenged as either being simply a penalty and not related to reasonably anticipated damages, or they're simply viewed by a court as being unrelated to competition. In other words, if the damages amount is based on what it would cost to find a replacement physician, a court is likely not going to uphold that type of provision. So those are things to be aware of. And I see we have a question. Are providers without a non-compete allowed to contact or notify patients of their new location or practice, especially if they need to use the patient demographic information in order to make contact? If they don't have a non-compete, typically they are allowed to do some type of transition letter in conjunction with the practice to notify the patients of the new location or practice information so that the patient ultimately has the choice. In Colorado, for example, we have rules in place. It's not a law, but there are rules in place for physicians that physicians cannot abandon a patient. And so, and there are kind of counterparts to that, which talk about if a physician leaves a practice, there should be coordination between the physician and the practice to notify the patient. I don't know that every single state has the same exact rules, but I would expect there to be similar rules and expectations when a physician is leaving practice, again, to ensure the patient has a choice in who they use for their treatment. There is also a carve-out in Colorado that's new, and that's for physicians who treat rare disorders. If a physician is treating a rare disorder, you can't tie them up with a non-compete. Now, that's obviously going to be a small subset of physicians out there, and there may be some disputes over what exactly a rare disorder is, but that's, again, something to be aware of and part of the trend, I think, of continuing to just kind of tamp down on these non-competes. So Laura, you want to take it back over from here?
Absolutely. So there are a few key takeaways here. The first is keep an eye out on changes in your state laws. You want to make sure that whatever non-compete provision you're using now remains compliant. Second, and this is probably good news for those of you who use them, in most jurisdictions, non-compete provisions are alive and well, as long as they are reasonable in duration and geographic scope. And this includes many of those states participants on this webinar are from, including Utah, Wyoming, and Idaho. So that's good news. And the last thing I want to mention, and Mark kind of touched on this a little bit, is that even in those states where reasonable non-competes are enforced, employers are inserting additional language like liquidated damages clauses that help dissuade employees from risking breaches in their agreements. Another thing that we see employers using is a statement that the physician's tail insurance coverage will be terminated. These things incentivize physicians, because they're so costly to the physician, if he breaches the agreement, it incentivizes the physician to not take the risk of breaching the agreement. So those are two things to consider for your physician non-compete. I think, Mark, you're up next with leaves.
Yeah, this is another trend we're seeing in a lot of jurisdictions. Again, Colorado is one of them, but certainly not the only one, where we're seeing states and cities enacting paid leave laws. What I would say on this is, even if you have what you consider to be a fairly generous policy, don't assume it's compliant with state law unless you're, checking it at least once a year to make sure that there haven't been changes. And a lot of times what we found is, working with healthcare clients, the policy itself provides more generous leave than what's allowed or required, I should say, what's required or mandated by state law for the most part. But then there are some gaps. And the most common gap that I've seen is the per diems, the nurses who are working just part-time, or you've got some part-time staff who are coming in 1 or 2 days a week. Be really careful, because sometimes state law, including Colorado, doesn't have an exemption for example, per diem staff. They are entitled to accrue time off just like anyone else. That seems odd, I know, sometimes for per diem staff, but just something to be aware of and keep an eye on, because it is that is something that we're seeing expand in various jurisdictions. And again, for anyone in Colorado or has employees in Colorado, you know, we do have a new paid sick leave law in place, the Healthy Families and Workplaces Act, and it definitely is it's a game changer in terms of how organizations have to deal with paid time off. A few other state laws to keep an eye on. It's a little hard for me to say this first one with pay equity is a trend. We certainly are seeing a few states, again, Colorado, California, Massachusetts, and there's a couple others that have enacted pay equity laws and rules. Some of these requirements are pretty strict. It's not just what you would think when you hear pay equity. For example, it's not just, look, you have to pay men and women the same if they're performing substantially similar positions. That's the baseline for sure, and a common thread of these different statutes. But some of them have other requirements. And again, Colorado is just an example, but one that I don't know yet if some other states are going to follow, but Colorado, for example, prohibits employers from asking applicants about their wage history, with the idea that if women have historically been paid less than men, then asking about their, you know, what they've been paid at their current job when they're looking to change jobs or at their most recent job is likely to simply continue the cycle of pay disparity. But Colorado goes well beyond that and beyond even California, I believe, in terms of having some very strict posting requirements, so that if you have a job opening or promotional opportunity, and those are, a promotional opportunity is very broadly defined, you have to let your employees know about it, you have to tell them what the pay or pay range is, and you have to give them some idea of what the benefits are. So all things to keep in mind as your number one, if you have anyone in Colorado or any of these other jurisdictions that have enacted any of these laws, something to keep an eye on. But number two, something to keep an eye on just with respect to you know, other jurisdictions going forward, as they may be looking at putting some of these types of provisions into place. They're strict. Colorado's penalties range from $500 to $10,000 per posting violation, which is significant. Now, Colorado's law is being challenged, but we haven't seen how that's going to turn out. We don't know how that's going to turn out, and so we'll keep an eye on that. But my hunch is that if Colorado's law is upheld, and a lot of times when these laws are challenged, they are upheld, other states may look at that and say, you know, we're not going to do exactly what Colorado or California or Massachusetts have done, but we're going to do something somewhat similar. So all things to be aware of. And if you don't regularly conduct pay equity audits, something to think about, and something I would recommend. If you're in Colorado, I definitely recommend it, even if you're in a state that doesn't have a pay equity law at this time. It may be something worth thinking about and considering to identify proactively and address any potential pay disparities. All right, Laura, I'm going to turn it back over to you for diversity, equity, and inclusion.
Thanks, Mark. Speaking about equity, right? So we're unsure whether diversity, equity, and inclusion initiatives are a trend. I think the hope is that one day we're not going to need them, right? But we know that these issues, especially issues surrounding race, gender, or identity, are a recent focus of organizations across the United States. But as a healthcare organization, DEI should matter to you because it may have the most impact on the healthcare industry. Studies show that DEI initiatives directly affect patient outcomes and quality of life. And the AMA even took a position recently stating that racism is a threat to public health, to the advancement of health equity, and a barrier to appropriate medical care. And I'm happy to share information on that article if you'd like to see it. So how do healthcare organizations get these DEI, or if you've got them started, how do you make them stronger? So I've outlined a few strategies. They're factors to consider as your organization approaches its DEI efforts. The first one is know your constituents. And by this, I mean assess your organization and the community where you are. So how diverse and inclusive are you? Would your employees agree with your answer? Would your patients? And how do you measure DEI? So one example we see hospitals using patient and employee surveys, which help learn what the perception of DEI is in your organization. But any organization can use that. Second, bring everyone to the table. It sounds like a cliche, but to truly make an impact, you need to hear all of the voices in your organization and your community. Your DEI committee or focus group should include not just staff, providers, and leadership, but patient advocates and community leaders. If your community has a university, bring in students. If you serve a reservation, bring in tribal leaders. Third, get leadership buy-in. If your leadership is not on board and committed to DEI initiatives, then your DEI efforts likely won't succeed. The tone is set at the top. Employees know when it's just lip service. So, you got to firmly believe in it. Your leadership needs to firmly believe in developing a plan, which is the next factor. Set concrete goals over a fixed period of time. There should be specific programs and trainings with specific individuals who will implement and manage them and hold these folks accountable. And last, measure the impact of your initiatives. Define what success looks like, maybe the number of training sessions or increasing the number of candidates you've recruited with diverse backgrounds. Tracking progress is key to making sure the objectives are being met. And if Mark, if you would advance the slide, that'd be great. So these are just a couple real world success stories that you might be interested in. You can look it up. The first is Mercy Health West. It's a multi-campus hospital in West Michigan who decided to tackle the issue of interviewers in the hiring process who are inadvertently discounting otherwise strong candidates due to their unconscious biases. We've all got them. Mercy Health redesigned their hiring process around tests for specific skills and standardized their interview questions to assess predetermined competencies. They were able to increase the percentage of non-white hires by more than 11%. They reduced the time to fill the positions by 6 days and decreased first-year turnover by 6.6%. I have to say, we use this at least in my Cheyenne office at Holland and Hart, these type of objective tests, and they absolutely work. I've appreciated using them and getting to know how they're applied. So the second success story is from Johns Hopkins. They aimed their initiatives at increasing employee diversity. In 2015, they started Hopkins Local, an initiative committed to hiring in 16 economically depressed zip codes with the goal to fill 40% of targeted entry-level roles from these areas by 2018. And they've had success, and they've been working with local faith-based communities and other groups to recruit these candidates. Mark, if you would advance the slide. So I think this might be the most important slide out of the three, because almost all Fortune 500 companies have initiatives in place, but many of them fail. And there are many reasons for that, but I'm going to focus on three of them. The first common mistake is focusing on one demographic. So a lot of companies will focus on women or racial minorities. But if you do that, you don't get buy-in from the entire organization, especially if part of your demographic doesn't see anything in it for them. So if you focus on just women or people of color, and if the dominant group in your company is Caucasian males, then your initiatives aren't going to work. A good example of this is family leave policies. Research has shown that women move to leadership roles more quickly in a workplace where men take paternity leave and where the leave policies are identical. So it really makes sense if you think about it. When women take maternity leave, it often has a stigma of lack of commitment to the job. But when everyone takes family leave, the stigma disappears and it just becomes the way the company operates. Second, not casting a wide enough net. To help make your DEI initiatives effective, you have to do more than keep track of your organization's demographics. You have to ensure that you have diversity of perspective and experience. So look outside of your specific geographic region when you hire. Make sure you aren't inadvertently leaving out candidates because of their age or the amount of work experience. And, for a pragmatic way to do it, maybe consider hiring a different search firm to find a new pool of candidates. And finally, DEI initiatives can backfire and they can have consequences, which is really interesting if you think about it. DEI initiatives and pro-diversity rhetoric can lead historically non-diverse groups, for example, Caucasian males, and I feel like everybody's always picking on Caucasian males, but so it leads non-diverse groups like that to believe that women and minorities are being given preferential treatment. On the flip side, diverse employees, those you believe your initiatives are trying to help, may feel they are being singled out and they become the focus of attention that they may not want, especially when they feel they have to disclose personal information they don't want. So be aware of the potential discrimination issues associated with your DEI initiatives. Mark, would you please advance the slide? So this is one of those high-risk topics that Mark mentioned earlier. And it's our last topic. So documenting employee performance issues. Employment lawyers can never stress enough, and Mark would agree with me, the importance of documenting your employee performance or behavior issues. The outcome of labor grievances, agency charges of discrimination, and lawsuits literally often come down to a supervisor or manager's record of employee issues. This is true for a supervisor who supervises one employee up to the CEO who manages the C-suite. At the end of the day, managers need to document employee issues to mitigate risks associated with the myriad of claims an employee can bring. Wrongful termination, claims of discrimination and retaliation. When attorneys defend their employer clients, we argue that our clients took adverse action against the employee, whether it's discharge, demotion, not hiring, for legal reasons, not illegal ones such as discrimination or retaliation. But we can only make that argument if you give us the documentary support for management decisions that we need. Proper documentation provides evidence that performance issues were discussed with the employee in a timely manner. It also offers the employee's improvement or failure to improve performance over time. It should be chronological and a precise description of the employee's actions, the manager's actions, and the events. And documentation can offer proof that one employee deserves or opportunity over other employees who are also eligible. With respect to what documentation must be provided, in the later review of documentation, what's needed is an accurate record of the conversation. And I'll talk about that in a minute, but the general idea is to stick with the facts. The manager needs to write down dates and times of the conversation and what he or she said and what the employee said. The documentation should be ambiguous. It should get the facts straight. In any potential legal situation, errors in any of the documented events can make all the rest of the documentation so. And last, when should the documentation occur? It should be written during or immediately following the meeting or conversation with the employee. Waiting until later the next day affects the quality of the documentation because, as we all know, our memories are short. Mark, if you would please move to the next one. So just a quick run through of what needs to be documented. What really, or what this really also does, which is great, is it outlines the manager's conversation with the employee, what they should be having with the employee. If you train your supervisors how to document correctly, you're also providing them with guidance for how to structure the coaching or the discipline conversations. So first, the record of the conversation needs to state the company's expectations from the policy or the job description. So not just, something like show up to work on, but be specific. State that, employee, your shift begins at 8:30 a.m. We expect you to be at your desk and ready to handle calls at that time. At the end of the day, consistent, clear, and well-written performance expectations are critical if you want an employee to succeed and mitigate your risk. The next two bullet points go hand in hand. When supervisors summarize the misconduct, a clear statement of the facts focuses on what the supervisors know and doesn't include speculation or unverified information. For example, state that the employee reported to work 2 hours late. Don't speculate that it was probably because he was out drinking last night. And always describe the conduct, not the individual. So you don't want to write something like she had a bad attitude, but maybe something like, at the last team meetings, you have complained about your coworkers, instead of adding meaningful comments, something like that. Including the employee's explanation shows the manager attempted to be fair and is trying to help the employee. This goes a long way in a charge of discrimination or a lawsuit. It also helps the manager avoid a rush to judgment, which is a good thing for everybody. And finally, provide a specific plan. This gives the employee a successful path moving forward. And it's not necessarily a performance improvement plan, but coaching. And it should include specific steps the employee needs to improve, a timeline, and perhaps what the supervisor will do to help. Also include any statements made in the conversation related to consequences if the employee doesn't take those steps. For example, and I know you probably all have these in your policies, but statements in the documentation that, failure to meet these steps will result in further disciplinary action up to and including termination. You say that in the meeting, document it on a piece of paper. All right, Mark. So just a few more words on what not to document or say in those employee conversations. And that's as important, if not more important, than what you should be documenting. So first, diagnose why an employee is performing poorly. Even if you or your supervisor suspects the employee's divorce or their finances is affecting his performance, don't put that in formal documentation. And never point to the employee's medical condition as a cause of the performance or behavior problems. If you do, you're going to open the door to claims of disability discrimination, because now the employee can argue, hey, you didn't give me that promotion because I have MS. It has nothing to do with the fact that I've not been doing my charting in a timely manner. So make sure you're not documenting condition. For the same reason, documentation should not include statements that overstate the facts or generalize the issues. Statements like, he was terminated because he was not a good culture fit, or the bad attitude comment, or calling a dishonest act fraud. Those become flags that cause an employee to believe he was fired because of his race or gender or another protected class. And time and again, we see charges of discrimination based on this. And when we dig into it and we investigate, we realize, oh, it really wasn't fraud. Or no, it really wasn't a bad attitude. Here are the specific facts you could have laid out. So you could prevent those charges of discrimination before they even happen. You should not, or your supervisors should not include their mental impressions in the documentation. For example, a statement like, and we see this a lot, I thought my directions were clear to her. If a supervisor is writing that, then the directions were probably not as clear as she thought they were. So that concludes the issue of documenting employee performance issues. I don't know if anybody has any questions for Mark and I. We're happy to take them now, but just want to say thanks for joining, and a reminder, and I don't know if Mark, if you had any other words, but a reminder that the recording of this webinar will be posted on the healthcare blog on the website within 24 hours. And also, and Mark, I'm not sure if you mentioned this earlier, but just a reminder, a certificate of attendance can be provided to you if you request it. So I believe you need to check the website for information about that. So unless there's questions, that concludes our employment law issues and trends for healthcare compliance boot camp today. But please, if you have any questions, let us know. We're here.
Yeah, thanks, Lori, and thanks everyone so much for participating. We will stay on for just another couple minutes here since we ended a little bit early, just in case folks do have questions. But really appreciate everyone's time and attention, and we hope this was helpful for you. All right, it doesn't look like we're going to get any more questions. So again, thanks everyone, and Lori and Luke, thanks to both of you, and we'll sign off.
Thank you, everyone.